So today we're going to talk about legal opinions, and this is in some ways going to really sum up Chapter 8. Chapter 8, the chapter on authority. And legal opinions are evidence of authority. And so we need to apply what we've learned over the past 2 weeks to this subject matter to really understand, make sure that we understand what we've covered so far. And so what are legal opinions? Well, they're memoranda. They're actually letters, oftentimes sent from counsel to the opposing counsel or the opposing client in a corporate context. And they express the lawyer's conclusion as to how the relevant law applies to a fact pattern. Just like what we often do, but we're doing this analysis in a corporate context and saying whether or not an action has been authorized or whether or not a statement of fact about a corporation is true. And these are often requested by parties to a transaction who want assurance that that transaction is going to be legally binding. Because as we can see, there are, as we saw from our last 2 lessons, if an action is not authorized, the corporation may not be bound by it. And so if you're opposite of a corporation and you're in a transaction with them, you want some comfort that that corporation's actor, their agent, is actually authorized, and I do mean actually, I mean expressly and actually authorized to conduct that transaction, so it's not retroactively rescinded, kind of pull the rug out from under you, so to speak. So what function does the legal opinion serve? They can serve any kind of function, but usually it's like a housekeeping matter, and sort of you kind of look at the records and certify that the state of the corporate affairs are a certain way at a certain point in time. So when this boots up, yeah, there we go. It's a little dark, but I have an example for you. So let's take a look at this first example. All right, so what do you notice about this? Well, first off, the date is in brackets, and those square brackets are sort of a tool that lawyers use to denote that we're going to change something later. So what date are we going to put for this? So we're contemplating a transaction, so what date are we going to put for this letter? So you might think the date you're mailing it out, right, or the date that you wrote it, but the relevant date of a transaction, what do you really care about, in a transaction? Yeah. The closing date of the transaction is going to be what's really fundamental. And so we're actually going to date this as of the closing date. So it's actually not the date that you write it on. And what we're going to be certifying is that a number of things are true as of the date of the closing, because that's the date that matters. And so, look, if the corporation had 1 million shares of stock on Thursday, and then they issued another 5 million on Friday, and you bought the company, or you bought 1 million shares on the next Monday, you didn't get the percentage that you were hoping for. So the letter, the certification talking about the capital structure, it has to be true as of the closing. And so legal opinions are going to be dated on the closing date because they describe a legal situation that must be in force at the time the transaction is consummated. So who do we address this to? Other than ladies and gentlemen, but who are we going to actually address this? Yeah, well, we actually tend to address it to the other party, and their lawyers read it. And so the convention is to address it to the other party, but it's really their lawyers that are going to care about it. So it is kind of funny. We don't address it to the law firm, though. We actually address it to their client, the other law firm's client, and the law firm reads it. And the reason that we do it that way is that we're actually generally going to limit the effect of this letter to the addressee. And we're going to say that only the person that we address this to can rely on it. It's only intended for them. And so their client can rely on it, and their lawyer will inform the client that it's sufficient and valid. And so the lawyer delivering the opinion will tend to limit the addressees and limit who can rely on it to as few parties as possible, and normally that is the other party to the transaction, the one seeking, we call it comfort. We're going to comfort them and tell them everything's okay. You're going to get the shares of stock that you bargained for, and you're going to pay the price that you expected. How does the lawyer describe his role? And as you can see, the lawyer here describes their role as counsel to the client in connection with the transaction in question. And this is relevant because sometimes, for example, in a merger or acquisition, you might have a different counsel who performs that merger, as opposed to the counsel that represents the company on a day-to-day basis or represents them in terms of engagement. And sometimes a lawyer who is specially engaged just for this transaction might describe themselves in that way and express and make it clear to the other party that their knowledge of the client is limited to the transaction in question and to the documents that they reviewed. Because as we'll see, the lawyer actually takes on some liability for the assertions made in this statement. And so the idea is really to try to limit the assertions that you might make so that you make it to as few people as possible and you say as little as you possibly can, because your license and well, hopefully you have malpractice insurance, but nobody wants to be collecting on that. And that's what's on the line here when you put this together. So take a look at this and sort of ask yourself, what does a lawyer have to do to give an opinion letter? What is the actual work involved? Yeah, this is the corporate version of doc review. And so the term for this is diligence. This is a corporate diligence process. So for those of you who have worked in litigation, document review means oftentimes you'll make a document request in the process of discovery during a litigation. Between you survive the motion to dismiss, or they just answer the complaint, and that opens a period called discovery where you do your fact finding, you get your depositions, and you get a lot of copies of records in corporate litigation. I mean, it could be huge volumes of records, and those are often digitized and scanned and sorted for responsiveness and privilege. So that's one type of document review, and that's corporate litigation document review. Corporate transactional document review, you're going to be reviewing internal documents from the company, and these will be like material contracts, stock issuances, other documents that are going to be relevant for you to be able to say that the statements in the opinion are actually true. So what we're going to be doing is this document review of a lot of corporate records, corporate documents, contracts the company has entered into, leases, sales of stock, all that sort of information. And sometimes, you're going to have to, as the attorney, rely on certifications by the company. And so the company has officers. There may be things that they know that are not provable by a document trail. So you may have the secretary certify that a meeting occurred on a certain date, or certify that the bylaws are accurate. So there's going to be a combination of documents and certifications of those documents that you'll rely on. And oftentimes, the documents will be listed. It depends really how many there are, but sometimes the documents will be listed in order for the attorney to, again, this is like total defensive mode here, right? And the idea is to limit your exposure to liability as much as possible, and by saying we are only opining as to the documents that we actually reviewed, which are listed on Exhibit A. Then if there's another document that your client didn't give you, you didn't commit malpractice, or at least you hope not to have committed malpractice. And so it can be a good practice. On the other hand, if you're on the other side of the equation, if you're the one receiving the letter, you may not want it to be limited, because then you're not getting the comfort that you bargained for. Then we get into a series of limitations. And so let's take a look at this one. The opinions set forth herein are limited to matters governed by the laws of the state of blah, da, 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 right? New Columbia in this case, we made it up. And no opinion is expressed herein as to the laws of any other jurisdiction. So if you're an attorney practicing in Pennsylvania and you don't know anything about Nebraska law, you don't want to be opining on Nebraska law. I mean, for one thing, that's a risk for you because you don't know that area of law. And maybe there is something weird out there. Maybe Nebraska, I don't know, has some weird version of the Uniform Commercial Code which doesn't permit, some exception for the statute of frauds in the case of merchants, and so the fact you don't, whatever. I mean, you just don't know, and it's not your job to know that unless you're asked to know that. And even if you are, you then have to become competent in that area of law to the extent possible. And so you're going to, again, protect yourself by limiting to the law of the jurisdiction at issue. In the case of corporate issues, this is typically going to be Delaware and the state in which the party, your client, resides. And so if you're a California lawyer practicing in Silicon Valley with a client that operates there and is incorporated in Delaware, you're going to limit this to Delaware and California law. And this gets a little tricky because, I've done this. I'm not licensed to practice in Delaware, but The general counsel of my firm told me that it's okay. Yeah. But you don't have to necessarily be licensed to practice law to opine on what the law is. And you see courts often will deal with the law of another jurisdiction, and Delaware is the one that kind of often sneaks in there. You have a question, John? Yeah. So if the contract is governed by, or the client is incorporated in a state where the opining lawyer is not licensed to practice, it may be necessary to have a second law opinion to rely on from a foreign lawyer. But a lot of corporate lawyers are familiar enough with Delaware law that they would feel comfortable opining on certain very limited matters of Delaware law. It's getting into a bit of a gray area. Speak to the general counsel at your firm if you have any questions about the ability to opine on law outside of your jurisdiction. All right, more limitations, right? We're going to keep limiting this based on and subject to the foregoing and further assumptions, limitations, and qualifications hereinafter expressed is our opinion that. So after we've made our limiting remarks, and by the way, there usually are more. We're not going to go through all of them, but this is often, by the way, a form. There's something called like the Tri-Bar Committee on Model Legal Opinions, and you can download a form on the internet that has a model legal opinion with all of the possible provisions. And usually they're lettered, and then we have numbered provisions for the actual opinions, but the sort of exceptions and limitations, and they can go like A through Z, really. I mean, there could be 20 or more limitations and carve-outs. We haven't looked at all of those. And then we actually make the opinion. And an opinion is kind of a funny word. It is called an opinion letter. But what does this mean, actually, opinion? It's actually stated, conclusions of fact, really. Facts that you found. So, it's kind of confusing to call it an opinion because it actually refers to specific opinions are really facts, and you're going to be held to them. So the word opinion has a connotation like a belief. It's not the technical meaning here. It's legal conclusions that you've reached based on your analysis of the documents. And also, the opinion is the whole thing. It's the whole document. But the opinion letter has a series of opinions in it. So let's take a look at our first opinion. The company is duly incorporated, validly existing, and in good standing under the laws of the state of New Columbia. What does that mean? Yeah, so duly incorporated means that means what it says, really. There was no defect in the incorporation. And what's funny about this, some lawyers won't give that opinion because it's actually hard to prove. I mean, how can you actually show that there was no defect? And so this is actually one opinion some lawyers don't always give. Validly existing, on the other hand, how can you prove a company is validly existing? Yeah. Yeah, you go to the Secretary of State. Well, so you mentioned you can check their website. The website will give you an unofficial information about whether that company is validly existing. But in order to have the kind of comfort that you would need, you would actually want to order a certificate from the Secretary of State. You wouldn't just want to rely on the website. You would actually want to go further and order a certificate. It's like $50, and then you have to pay like $1,000 to get it in an hour if you're in the middle of a transaction. They can rush it to you. And what it is, it's nice and not nice. I mean, Delaware can rush documents and they can process things as quick as an hour for an extra $1,000, or you can wait a week and pay $50. But you're going to want to have that paper in your hand that is stamped and sealed from the Secretary of State. No, I don't think you can rely on it. If you didn't personally incorporate this company, you should be very hesitant to give a duly incorporated opinion. If you did it yourself and you personally verified those documents coming back on time, and you feel comfortable about that, but most opposing counsel will not insist on the duly incorporated part. They'll be asked to give a letter at some point in their lives, and they don't want to give that either. And this changes. And again, there's bar committees that talk about this. Some attorneys are more comfortable with doing this than others, but it's not a preferred practice because it can't be certified.
Did you say validly existing?
Yes, you can say validly existing because the certificate will be evidence of valid existence. Right, so as I mentioned, some attorneys are not comfortable giving a duly incorporated opinion unless they were personally involved. Others are more comfortable with it. Again, there will usually be a person at your firm who is like the opinion guru, and it's a role I'd like. It's like a super nerdy like role of the firm, be like the legal opinion guy. But there's a guy who's like does that, and or a girl, and man or a woman, and you talk to them, and they will tell you what is the best practices that your firm has adopted. All right, what does it mean for a company to be authorized to transact business in a state? How do we give this opinion? So you have a Delaware corporation. You're here in Pennsylvania. Yeah, you have to register, like you would for a license. You register as a foreign corporation. And you might have to register for a number of other things. You might have to register to have employees. Delaware has a process called Delaware One Stop where you can get all these licenses. Pennsylvania, less so. Every state has their own procedures. But oftentimes, they will ask for a certificate of registration in every state where the company is doing business. And what constitutes doing business? I mean, that's not just sales. Remember that it isn't just sales, actually. I think that's an important point, because you might have employees in an office somewhere. I mean, you might have 4 people in an office in Vermont, and they're not necessarily making sales in Vermont. They could be working on intellectual property, processing patents, or whatever. So it isn't just sales. It could also be employment. But you want to have that registered ability to do business in states, certainly where you have a significant physical presence. And every state has their own standards for this too. So if some companies really need to register in every state. I'm sure Apple has a registration in every state in America. I mean, they have Apple stores, right? And that type of sales operation with a physical footprint, employees, products, shipments, warranties, liability, all those things would probably have to be registered in every state, but most businesses don't need to be registered in every state, just some where they have a substantial presence, at least in office. And so in order to do that, you're going to want to get certificates from all of those states. And so this can take some time. And so you want to be ahead of this. And so, in fact, when you're going to go through this process, if your firm has done this before, at least a couple times before, they should have a checklist for you to go through and all these things to think about, because part of it is, in order to write this letter, writing the letter is easy. That's cut and paste. What's hard is being able to say these things are actually true, which means you have to actually get the certificates, which means you have to determine in which states you need a certificate, and then you have to order it, and then you're going to find out that your client didn't register in Oklahoma. And Oklahoma has some kind of rule that says if you have 3 employees, you have to register. And then you got to go and register in Oklahoma and then get a certificate for that. And all this has to happen before the closing, because the deal doesn't go because you couldn't sign the letter. Well, your client's not going to like it. Just put it that way. So good to have a checklist and think about this ahead of time. All right, this one directly relates to corporate. And what's interesting here is this really is a Delaware law issue, in my opinion. Although, if you have a corporation, if you're in Pennsylvania, you have a Delaware corporation, what your authorized stock is going to really be a Delaware law issue. But anyway, the authorized capital is going to be a really, really important opinion for anyone who is interested in buying your company or buying shares of stock in your company. Because this is telling them what are they getting. I mean, a share of stock is just a percentage. If there's 1 million shares and you're getting 100, that's not much. If there's 1,000 shares, you're getting 100, that's a whole lot. And so you want this to be true as of the date of the closing. If you're investing in a company, you want to know what you are getting. And so this opinion would rely on seeing a copy of the certificate of incorporation. And again, you're going to want to go to Delaware. You're going to get a certified copy of that certificate of incorporation, because that's the document that says how many shares are authorized. Now, how do you know how many shares are issued and outstanding? So they should be maintaining a stock ledger, and so you could look at their stock ledger. If your firm has been maintaining that stock ledger, that may be sufficient. But if you're just taking this client on, can you rely on their stock ledger without more? Again, your law license is on the line if this is wrong. What else might you want to see? I mean, if you really care about this, you're going to want to see every contract for the issuance of stock and every board resolution authorizing that issuance of stock. Only the board can authorize the issuance of stock. The CEO can't do it, and you can't give the CEO that power in the abstract. You can't say, hey, CEO, issue stock whenever you feel like it. An issuance of stock requires a board action. And so we're going to want to trace back every stock issuance to an actual board action. We're going to want to find a resolution either at a regular meeting or at a duly noticed special meeting with quorum and with sufficient votes approving that issuance of stock, or in the alternative, a unanimous written consent by all the directors. Right? That's the only way the stock can be validly issued. And there are issues that come up with this. So there may be an instance where stock is not validly issued, where a deal was signed and the meeting wasn't done properly or wasn't done at all. What can you do in that instance as part of your house cleaning? What's that called? A ratification. You would want the board to ratify that issuance, and then it will become valid retroactively. So you'd want to have the board have another meeting. And by the way, they don't necessarily have to have a meeting. They might be able to just sign a unanimous written consent. Now, they're going to get really annoyed with you if you have them sign a bunch of these things. So what you usually do is you compile a lot of these cleanup issues until a period reasonably before the closing, not too close, but you want to get through as much diligence as you can, identify as many problems as you can, and then you're going to ask the board to ratify and clean up whatever you can clean up at that point. The company has the power to execute, deliver, and perform its obligations. So how do you know if a corporation has power to enter into a transaction? What's the subject of this chapter? Authorization. How do you find whether a company was authorized? Well, it seems like this is a big transaction. You don't just write opinion letters for fun. These are expensive, they're hard, you put your license on the line. You only write them when you have, almost by definition, an extraordinary transaction. And what do we know about extraordinary transactions? What do they require? Yeah, you need an action by the board. You need an express grant of authority for an extraordinary transaction. We're not going to simply rely on the nature of the CEO or the fact that he did something like this before. If it's extraordinary, we're going to want to see an express grant of authority, a board resolution. So in this case, this is a merger, this is a sale of a lot of stock, an amendment to the certificate of incorporation, bringing on new investors, changing the makeup of the board, or a major shift in corporate policy, maybe a huge $100 million revolving credit line or something significant like that. We're going to want to see an authorization from the board, and we're going to want to see that they actually sat down and looked at the deal documents. We want to see a resolution that the board adopted and approved the documents attached here too as Exhibit B, et cetera, and we want to know that they went through that paper and process. We're going to see a case Van Gorkum, and in that case the board approved a major merger in like 2 hours, and later there were some real questions about whether that was a breach of the duty of care. Right? We're going to get to duty of care next semester. And in the Smith v. Van Gorkum case, we had a potential breach of the duty of care because they didn't spend. And actually, I have this picture that I put on one of the slides. For a while after that, you'd have the counsel stand over the shoulder of the board members and be like, all right, now turn to page 634, initial, 635, initial, to make sure that they were going through the proper, what we call paper and process, that it was authorized. So it actually is significant that the board look at the documents and have some authority that comes not just from mere words, but from some actions. So we have to find then that grant of authority. And it also is saying that this is within the scope of what the company can do. So this can't be anything illegal and things like that, although there are other opinions that capture the legality component. Right, and we really care about this authority concept, so there's also going to have an opinion that the company has authorized delivery and performance of the transaction documents. And this means that the corporate actions opinion, this is called the corporate actions opinion, means the company has taken all the steps it needs to authorize the signing of the documents, the act, right? Because you have to have a human being. Corporations don't have arms, right? They don't have hands. You need a human being with a hand with a pen in it to literally sign a document, and that means you have to authorize that particular person to sign that document. So you're going to want to see language to that effect in a resolution. And we're going to want to see a grant of actual authority, right? The fact that we're in the world of legal opinions, this is not an ordinary transaction. We're going to want to see a grant of authority. So what does the lawyer look at? The lawyer might look at the articles, the certificate of incorporation, the Secretary of State records, corporate articles, bylaws, board resolutions, secretary certificates, the transaction documents. There's a lot of diligence involved here, a lot of looking through the corporate records for evidence of authority. All right, so this is called the Remedies Opinion, and it says the agreement constitutes the legal, valid, and binding obligation of the company, and it's enforceable against the company. So it's called the Remedies Opinion, saying that if the company breaches it, there will be a remedy for the other party. You can see why they would want that. They'd want to know that this is an enforceable contract and that they have rights at law if the other side breaches. And so this means that the document in question is legal, that the legal requirements for the formation of a contract have been met. By the way, I teach contracts, so I talk about this a lot, but what does a contract require? Offer, acceptance, and consideration, right? And we're not going to look for a substitute here. We want to see clear evidence of all that. Now, there are some weird transactions out there where corporations try to basically have contracts without consideration, and they use magic words like for good and valuable consideration where there is none. Those become real issues here, right? You're giving stock to somebody, and they're not actually paying, and you know. So there is a tendency in legal practice for attorneys to try to use magic words. They don't seem to understand that the doctrine of consideration is real, and that courts actually will refuse to uphold contracts that do not have consideration, a bargain for exchange. So sometimes it can be silly stuff like $1 for 1 million shares of stock, and they think that's going to work because now it's $1. That's nominal consideration. That's not consideration. Courts can see through that. So that comes up in here too. So if you're opining on this, look, it's not a big deal. If you're selling a company for $10 million, there's consideration, right? There's the company, and there's $10 million. There's a bargain for exchange. Don't worry about that. But if it's more like giving away a huge amount of stock to somebody's nephew, right, that's not necessarily binding. There's not necessarily a remedy, and you're putting your license on the line for a contract without consideration. So don't forget the contracts require consideration. We're also then saying that the contract is valid, and by that we mean that the agreement is complete, that it's not so vague or confusing that a court would refuse to give it effect. So we should be comfortable that the contract meets those standards of a contract, that it's sufficiently definite, that it's binding in the sense that there's no public policy against it. I mean, if this is the contract for the assassination of somebody's uncle, that's not binding, right? Courts are not going to enforce that. It's against public policy. And so, I mean, that's not usually the type of thing you're writing an opinion letter on, and so this doesn't usually come up. But there can be other issues too. If someone's trying to sell stock and it's to a foreign national, there are some issues that come up with that. There are some issues with selling stock to investors in China. So, you know, those kind of things come up, and you need to make yourself aware of the issues there. You may need to get foreign counsel if you have a transaction like that, because there are some laws that prohibit certain international transactions. Securities law as well. I mean, you know, you have to, if you're issuing stock and it doesn't comply with securities regulations. So a lawyer who is writing this opinion letter has to be comfortable in a number of areas of law. There could be issues about employment that come up with a merger. It could be that you're, in addition to buying the company, there are certain people agreeing to stay on and to work for a period of time. Not all contracts for employment are enforceable. Not all non-competes are enforceable. So you have a lot of various issues that can come up here, and all those need to be vetted in order for you to give this remedies opinion, which basically at the bottom line says that this is an enforceable contract. And so you need to be comfortable that it is. All right, this one's a little longer, so take a minute and read it. This is called the no violation opinion, or the no violation of law opinion. So one thing to particularly notice about the no violation opinion is, again, we even have a more specific qualifier here, right, that we're only talking about information that is known to us, known to the lawyer granting the opinion, and we're not opining to things of which we do not have knowledge, and so we're trying to, again, limit our liability for saying things that we can't verify. And so this opinion means the opinioner has examined the document in question and compared it to the company's certificate of incorporation, compared it to the other agreements, and to the court orders listed in the officer's certificate, and found that there is no conflict, and this is permitted under the bylaws, this is permitted under the certificate. And this again gets complicated. So you've only seen a very simple certificate of incorporation, but we talked a little bit about preferred stock. So if you have preferred stockholders, this is your Series B. This is your opinion letter for Series B. That means you had a Series A. The Series A shareholders might have gotten certain voting rights. They might be able to veto a Series B transaction. In fact, they almost certainly will. I mean, generally, they're going to ask for that. They're not going to allow the common shareholders and the board to go ahead and sell Series B at any price. They're going to want to maintain some control over the future issuance of stock, or at a minimum, they're going to want to have some control over the amendment and restatement of the certificate of incorporation, because doing so can reduce the rights that they bargained for, which are in that document. So they probably have a veto right as a class of preferred shareholders, as a series of Series A have that veto right. And so the transaction, if it doesn't have the proper number of votes, would violate the certificate of incorporation. So it doesn't violate law, but it violates other documents. And so this no violation opinion means you have to have read the certificate, you have to have read the bylaws, and you have to, at some point you're going to have to actually count the votes and make sure that we get to the numbers that we need to have that approval, and to make sure we understand all the mechanics and whose protective provisions are triggered in this transaction. And so for this, we're going to again have to read the certificate of incorporation as well as other agreements that the company may have entered into. All right, then we have the no violation of law opinion. And this complements the remedies opinion, and it provides additional comfort. And so it may seem redundant, but there's a lot of redundancies built into these documents. Lawyers love redundancies. We love belts and suspenders and then whatever else, I don't know. Elastic waistbands, I don't know what else you add to belt and suspenders. Kind of like that, actually. Belt suspenders and elastic waistbands. So you have various levels of protection to keep the company's pants from falling off. So this violation of law opinion, or the no violation of law opinion, says that the execution and delivery by the company of the agreement and performance by the company of its obligations do not violate statutory laws or regulations. And of course, this would include securities regulations as well as state law. And so you have to become comfortable that that is in fact true. And it should, if you can say that, provide comfort to the other side that this transaction is valid. We're not done yet. We have more opinions. Next one, we're on to M here. What does this opinion cover? This is called the no approvals or consents opinion. So take a look at that. And what does it do? Yeah, so what type of state or approval might be needed for a transaction to occur? Oh, for sure. Yeah, if you're certainly, energy is a great example. The mergers in areas like, mergers of a power plant or something like that, they might be public-private partnerships even. Another area which is similar is like any kind of concentrated area, like if Verizon wants to buy AT&T, the government's going to get involved. It's called antitrust, and you're going to have a pre-merger approval process for that. And in fact, there are thresholds for that. And so if you're a company, I don't know the thresholds, so they change every year, kind of with inflation, but there's a concept called a Hart-Scott-Rodino pre-merger notification, and you have to file it and get approval and clearance, or an expiration of a 28-day waiting period if the companies are of a certain size, and there's a number of other factors. And so, you're dealing with a large merger, you now need antitrust counsel. And that antitrust counsel needs to either verify that you don't need a pre-merger clearance or you need clearance. Now, what can you do if you need clearance? Can you make this opinion? Yes, you can. And you do the same thing like you would in the disclosure schedule. If a representation or warranty is not true, you don't strike it. You have a disclosure schedule, and then you have that. It's sort of like an attachment or an addendum to the reps and warranties. Similarly here, you could have a mention of consents or approvals that are required. So you'd have this opinion, and then you would usually have a carve-out, and you would say, except for, Hart-Scott-Rodino pre-merger clearance. And by the way, that should be something you vet with the other side well in advance, and these big mergers usually have provisions to deal with that, and so they usually have some type of risk-shifting language. So if the clearance doesn't happen, one party pays the other $1 billion or something like that, some type of provision like that. So one type of consent that's often required, which is kind of oftentimes really hard to get, and this is just a little weird, is a consent from a landlord. So landlords oftentimes just have a provision in the lease that a lease has like a no assignment provision. In fact, if you have a lease, it probably has a no assignment provision. Check your lease when you get home. I'm sure you're all going to do that, right? But it probably has a no assignment provision, which means that the landlord would then have to consent or waive that provision. And if there's a change of control of the company, it depends on how the merger is structured. But literally like a rink-a-dink landlord could totally screw up a major merger by refusing to give consent. And so this no approvals or consents opinion deals with that sort of thing. So it's not just the federal government, but the rink-a-dink landlord. And it, especially because like some of them, it's like some guy has like, an apartment with like 4 commercial units, and he's just not checked into this process. And you've got some $7 billion deal, and there's like some guy named Jack who like just won't answer the phone and doesn't have a fax machine. And seriously, like something you have to deal with. So you want to get ahead of that. You want to get ahead of Jack without a cell phone and a fax machine. Because otherwise you can't give your remedies opinion. Sorry, not your remedies, your opinion. Your no approvals or consents opinion. Next we've got an opinion that says the opinions expressed above are subject to the following assumptions, qualifications, and limitations. Now, it's done different ways. Sometimes the limitations are first. And it depends on how your firm does it. Use their forms. Don't reinvent the wheel. I got in trouble doing that, by the way. I walked into a corporate law practice from litigation practice, and so I had experience, but not the right kind of experience. And like one of the first assignments I had should have been really simple. It was like draft a restricted stock purchase agreement, like the one we saw here. And as you've seen now, and as I now know, you just like either go to the website and you put stuff in a form and it spits out a 20-page document for you after you filled in like 10 fields. Or we didn't have hot docs back then because, this is ancient history, like 2009 or something. And so what you do is you ask the partner for a precedent, meaning a form that was done last time. So I didn't really get the concept. And so I started like reading through it and like changing everything. And he just wanted me to change the names and the numbers and the date. And he's like, I've read this 700 times, and you've been here for 3 days, and you've just taken my document and shredded it, and you don't know what you're doing. So don't do that. Just use the form of opinion letter. And so if it has the limitations before, that's fine. If it has limitations after, that's fine. After 17 years at the firm, you can join the opinions committee and change the letter. All right. So now in this particular example, we'll now move on to the lettered provisions and talk about the limitations. And again, this is in order to protect the attorney who's writing the letter. And there are some situations where the legal outcome is just not easy or even possible to predict. And so the opinion giver's knowledge of the company could be incomplete, or you might have to assume certain facts, and as a result, you're going to want to lay that limitation out so that you aren't found liable if it turns out not to be true and you just can't verify it. And these usually are contentious because counsel on the other side is going to want to strike your limitations, and you're going to want to add all the limitations. And so there's this like really kind of very like it's a nerd war. I mean, it's like the opinion committee chair versus opinion committee chair fighting about limitations and qualifications. And the client is like, just give me my $7 billion already. So here we have one thing very hard to opine on is bankruptcy. And so take a look at this carve-out, this limitation. So I don't do bankruptcy. I don't know if anyone here has taken a course in bankruptcy, but it's its own world. I mean, you have your own procedure, you have your own courts, and there's a lot of uncertainty about how bankruptcy is going to shake out. It's kind of like an arbitration. It's kind of like a litigation. It's kind of a mess. And it would be really hard to predict how a particular bankruptcy decision will be rendered. And so we're going to really try to protect ourselves that we're not bankruptcy lawyers. And so we're going to add this carve-out in here because of the uncertainty in bankruptcy. And I go over this a lot more in contracts class, but whenever you have equitable remedies, estoppel doctrines and things like that, and you have the reasonableness standards and what justice requires, what the heck is that, what justice requires? Do you know? I mean, some judge is going to tell you, but Judge A and Judge B will have different opinions about what justice requires. This judge will say justice requires the enforcement of this contract. Pay him, even though there was no consideration. This judge says, the next appellate court up flips it and says, that undermines the purpose of the consideration doctrine. It's not enforceable. Okay, I mean, you see these cases all the time, and you just don't know how they're going to end up. And so we're going to want to limit ourselves from liability, as the law of equity is messy, because it's an area where the judge has a huge amount of discretion, and we aren't going to be able to say with strict confidence how things will turn out. So we have that bankruptcy limitation. Then we're going to have a couple additional exceptions relating to attorney fees and arbitration. And again, this is another area where there's a lot of uncertainty, and how do you predict how an arbitration is going to come out? It can be multifaceted, and there's not necessarily strict precedent that will govern the conclusions of the arbiter or even who the arbiter will be. I mean, there's a lot of conversation about arbitration clauses and their enforceability. They dramatically affect the balance of power in not in a litigation, but in a dispute. It's one of the reasons why large companies love. By the way, why do huge companies love arbitration clauses? Sounds like the beginning of a really bad joke, but I don't have a punchline. Yeah.
They can choose where the venue.
So for one thing, they can choose the venue, and they often get repeat customers with the arbitrator, and so they get to choose not only venue but the arbiter, right? And so that's really helpful. Yeah. Other reasons? Yeah. You don't have to go to trial, so it's cheaper. But, that could cut both ways, because maybe the big corporation can afford trial better than the little guy, but not a certain type of trial. It precludes, so I think, my own personal conviction on this, it eliminates the risk of class action. And so class action is the one time, and class action is designed to allow a lot of little folks to gang up against the big guy. Well, the big guy doesn't like that, right? The big guy wants to fight a bunch of little ants that you can squish, and not a huge consortium. And so you see companies fighting really hard to maintain their arbitration clauses, because each arbitration is handled on a one-off matter. There's not a class action concept in arbitration. But for the points you raised as well, they get to pick the arbiter, they get to pick their jurisdiction in many cases, and they have these contracts of adhesion, these form contracts that are hugely asymmetrical and favoring the large company. In any event, we're going to try not to opine on arbitration. I don't know anything about arbitration. I've never been in arbitration. I didn't even take an alternative dispute resolution course in law school, so I'm not going to touch this one. I'm hoping I can get away with this limitation. No litigation. All right. Now, this is sort of interesting. You can do a litigation search, but we're going to want to try to put this in here. In addition, we advise you that to our knowledge, there is no action proceeding in law or equity, except as listed below. Now, what's interesting about this provision is, by limiting it to our actual knowledge, it creates what I call the ostrich effect, where we're like, don't want to look for it. This also pertains to trademark claims. I mean, if you actually have knowledge of a trademark infringement, there's much more heavy penalties and damages, so you don't always want to look. So this creates a kind of sometimes a bit of a perverse incentive. Yeah. Yeah. So right, you only limit the litigation clause to ones that you, the firm, actually represent, and you won't do a litigation search. I mean, the thing is, you start doing a litigation search, it opens a whole can of worms, and there's a lot of jurisdictions. There's not a straightforward way, as I'm sure you know, to search all the litigation in America. I mean, there could be some state court that doesn't have electronic filing and isn't on PACER. Every single state court. Yeah. Allegheny County has PACER? It has electronic filing?
They have electronic filing, it's not PACER.
Oh. But even the ones that have electronic filing, they probably all have different systems, and it's so annoying to have. I can't remember my password. Can you imagine remembering all the passwords for all the state courts? Yeah. And you probably have to pay and register for each one. You might have to certify. You might have to pro hoc vice into each jurisdiction. I mean, it's not feasible. There's no system to do that, and you don't want to do that, and I think in a way we want to keep that unfeasible so we don't have to give this opinion. So it's really hard to give that opinion, and it's a good practice to limit it to not just our actual knowledge, but that our firm is involved with. Yeah. But there is this sort of issue that kind of comes up in a couple areas of the law here, and trademarks and a few others, where you actually create an incentive not to look for trouble. And, we can have a policy conversation about that another day. Now, as I mentioned, you're going to address this to someone in particular, and then you're going to close it by saying this opinion letter is delivered solely for your benefit, the addressee, in connection with this transaction. And it may not be used by any other person or for any other purpose without our prior written consent in each instance. And why would you give it? So our opinions expressed herein are as the date hereof, which again, what's the date hereof? The closing date of the transaction, because that's what they care about. And we undertake no obligation to advise you of any changes in applicable law or any other matters that may come to our attention after the date hereof. So we're really trying to limit, only you can use this with all these limitations, only to the extent that we've made these specific opinions, and we're not going to refresh this. We're not going to continue providing you with updates. So we're always going to find this language in here. What happens if there is an error in this? Well, it turns out that it depends. I mean, a mistaken opinion letter is not necessarily fatal. It can lead to malpractice liability for the erring lawyer and for the law firm, but it doesn't necessarily. To collect damages on an opinion letter with a mistake, the disappointed party has to demonstrate the opinion was negligently rendered, right? Negligently rendered, and that losses were proximately caused by the negligence. So kind of a common standard, it's sort of a tort-style standard. In order to have a liability for an error in an opinion letter, the disappointed party has to show first that the opinion was rendered negligently, and that the losses that were borne by the disappointed party were proximately caused by the lawyer's negligence. So it's kind of like duty breach caused damages. So that's one reason why we're going to spend a lot of effort showing that we were not negligent. And so having a firm, having a committee that's going to review this is going to be often standard practice and procedure. Having a checklist and having the associate certify and having someone verify, having kind of multiple checks. Other things, lawyers tend to be very cautious about this sort of thing and very cautious about avoiding liability. Maybe too cautious, by the way. Heard an interesting paper the other way about whether lawyers add value as CEOs. And the answer is, it depends. If it's a firm that gets huge litigation that breaks the company, like pharma, a CEO who's a lawyer can really add value, but in most of the cases they don't. In most of the cases they end up decreasing firm value. And it's not a good idea to hire a lawyer as a CEO. They're just too cautious. They don't take the type of risks that you need in most businesses that aren't heavy on litigation. But it kind of makes the point that lawyers are very cautious as a rule, and opinion, from my experience, the chair of the opinion letter committee is the most cautious of them, and so there tends to be a huge amount of process involved with these letters, and so in truth, very rarely do these letters result in actual liability for big law firms. They have a very formal process to avoid. So the question again was, how long does it take to write one of these? Not just to write it, but to do all the diligence involved. It's so variable. If you have a company, like I mentioned, going through a Series B financing, they're pretty young. They probably don't have hundreds and hundreds of offices and landlords to worry about. But you get a company like Apple, right, which has, it could have, I don't know, how many stores do you think Apple has? It could be thousands and thousands. And each one of them you have to read the landlord agreement, right? So you get these mega mergers, and you need hundreds of attorneys. And you need someone to manage teams of hundreds of attorneys for this thing to get turned around in any reasonable amount of time. But these things can happen quickly. It's called tying out, like all of the stock issuances, getting all the stock issuances to relate back to an actual board grant, and then and tying that out to the actual stock document, and finding the certificates and kind of getting it all organized. You have to, if you really love organization, and you just if you love Microsoft Excel and organization, this is pretty cool. So how many hours? It depends. Some of these deals do get put through pretty quick. Look, there's a lot of jokes about the lawyers get paid too much money, but the truth is there aren't a lot of people in this world that can do that. And when you need to have a transaction for $7 billion, completely reviewed and edited and audited and taken care of in a 3-day window, or at least to the point where you get to signing. It helps if there's a separate sign and close, and there are other kinds of aspects that you can do to build in a buffer if it's just not possible. But yeah, I mean, I think it's really impressive. I mean, that's one of the reasons I love corporate work, and I really respect, real corporate attorneys, because it's an incredible skill to have that type of management prowess, I think. A financing is easier than a merger, because in a financing you don't have a change of control, and so you don't have a concern like with the landlords, like the rink-a-dink landlord, Jack with no cell phone and no fax machine, who has 4 office buildings that you rent from. You don't have to deal with him because there is no change of control. It's really just about the authorized capital, and even for a very, very large financing, they're not concerned. And oftentimes you'll have repeat players, and so by the time you get to your Series D financing and you're getting $100 million from Andreessen Horowitz or whatever, Benchmark Ventures, they're going to have been with that company, and they're going to be on the board, and they may not require this level of comfort either. And they don't want to cause that expense because it's much more of a ongoing relationship. And they don't want to have $15,000 or $40,000 spent on generating this opinion letter. So, I mean, that's opinion letters, and I think that it really kind of brings together a lot of these concepts about authority, and I think it gives you a real world sense, I hope, of what it is like to conduct this type of operation. It can be really exciting and thrilling. It can be really mind-numbingly boring. It can be 2 in the morning and you want to go home. I think it's true of a lot of different areas of law practice. I guess kind of as kind of closing this up, in conclusion, I would say that corporate practice is not for everyone, but I think it's a really exciting area of the law because you get to work on these huge transactions, and everyone wants the deal to get done. I mean, there is other sides, but we're all working to a common goal. Both you and the other law firm want the deal to close, and nobody wants to be the one who blows it up. At the same time, you have this responsibility to your client to really verify that everything's accurate. I think it's good for people who like working on a team. I mean, you have to figure out a way to work with a lot of different people. And you've got your support staff, and you've got your paralegals, and you've got your partners, and you've got the partner over in the IP department who you need to get stuff from, who may or may not be getting paid enough in his opinion for this, and you've got some landlord in Kennebunkport who doesn't have a fax machine that you got to convince him to sign something he doesn't understand in order to get a $7 billion deal to close where he's not getting a dime. And you've got technology to work with and a share room and maintaining a paper trail and negotiating on even the opinion letter itself and what needs to go in the opinion letter, and trying to identify who it is that you need to talk to in order to limit it to the extent you can, to reduce costs. And so you a lot of different constituents to think about, and a lot of different areas of work. I mean, it's not all just M&A. That's one of the bigger areas, but you saw also the incorporation aspects and working with the founders and the CEO. And I mean, it's great. I mean, they're really happy. I mean, closing is like a fun thing. They used to give little deal toys, like you'd close and there'd be like a little, usually like what's it called, like one of those plexiglass things. You've probably seen those at the office, right?
Like the glass cube.
Yeah, a little glass cube. There's like a hologram in it. It says like $1 billion or something, and and that's what you get. It's kind of like how at the firm, if you work 250 hours in a week, you got if you work 250 hours in a month, you'd get a $250 gift certificate for a restaurant. And so if you spend 1,000 hours and you close a $7 billion merger, you get a little acrylic toy. Just put it on your shelf. So it's not for everyone, but I hope that this course has at least exposed you to a kind of a new way of thinking and some new concepts, as well as given you foundational knowledge for the bar exam and prepared you for next semester. So we'll come back next week and have a kind of a Q&A session and then wrap up for the exam. But for now, thank you.